Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It is difficult to think of another criminal case that was as sealed to the public as Idaho versus Kohberger was and still is. 8+ months after Mr. Kohberger stood up in open court and changed his plea from not guilty to guilty of all 5 of the very serious felonies that he had been charged by operation of a secret grand jury that returned an indictment back in May of 2023. That act canceled the preliminary hearing that was supposed to happen the end of June 2023, where, just as what was seen in another Idaho courtroom this past week in another highly publicized criminal case, State of Idaho versus Wandra, when the state was required to go into an open and public courtroom where the public was free to go in and observe, where the press was there, recorded certain portions of that preliminary hearing, and where the state of Idaho bore the responsibility of convincing the trial court that there was sufficient evidence to continue to hold Mr. Wandra over to trial. That never happened in Idaho versus Kohberger because of the indictment that was returned and canceled that preliminary hearing. Adding to the secrecy of the case is the fact that on day 4, back in early January of 2023, state and defense convinced the first judge in the action, Judge Megan E. Marshall, to enter a non-dissemination, aka a gag order, that was not rescinded until after Mr. Kohberger pled guilty in July of 2025. On top of which, there were hearings after hearings after hearings, not like the preliminary hearing in Wandra that was public, but were behind closed doors. And then there is what I have called the virtual Mount Everest of documents that were under seal in the case as a result of orders being entered after the state or the defense, or sometimes, as with the gag order, when they stipulated or they agreed and went to the court together, asked to have certain information sealed from public disclosure, critically evidence that the state believed that it had that would prove Mr. Kohberger to be the sole and the correct defendant responsible for the crimes at 1122 King Road, beyond a reasonable doubt. After the case was closed, Judge Hippler entered 3 orders going to the parties, asking them for their objections or non-objections to documents being released to the public, starting with July and June of 2025. Second order, May and April of 2025. Third order, that was rendered in October of 2025, dealt with items under seal for January, February, and March of 2025. The only documents that have ever been released, a handful of documents from July, June, May, and April of 2025, and one from March of 2025. Judge Hippler rendered an order December 18th of 2025, directing that dozens upon dozens of documents were to be unsealed to the public. As of today, just one document from the first quarter of 2025 has been released to the public. What is the holdup? We don't know. There has been no explanation as to what has happened here. What we might be able to glean some kernels of information as to what's caused this basic standstill of unsealing documents in the highly sealed case is a gander at the very last document that appears on the court docket. that was issued a month and a half ago. This is the January 29th, 2026 order sealing state supplemental. This means an additional response to the court's third order regarding sealed documents. So what's happened here is that while the state did issue a response to that third court order dated October 30th, if you would like to read it, they came back and filed a supplemental, an additional response to that third court order. And this order of January 29th, 2026 is sealing that response and is sealing the exhibits. It states here, based on the state's supplemental response to the third order regarding sealed documents and motion to seal filed herein, the court does hereby confirm and order that state's supplemental response to court's third order regarding sealed documents and attached exhibits is exempt from disclosure and is sealed, big capital letters, pursuant to Idaho Court Administrative Rule 32G1 for the reasons stated in the said motion. This is so ordered January 29, 2026, signed by Judge Stephen J. Hippler, District Judge. If we go to ICAR 32 GI and look at that rule, it is entitled Idaho Court Administrative Rule 32, Records of the Judicial Department Examination and Copying, and then exemption from the limitations of disclosure. And if you read this rule, it tells you that there are certain grounds for the court to withhold documents that would otherwise be disclosed to the public pursuant to the Idaho Public Records Act, Section 74104. Under G1, documents and records to which access is otherwise restricted by state or federal law. At this time, it is unclear of the dozens and dozens and dozens of documents that were ordered to be released on December 18th, 2025, absent one that was released last week dealing with text messages, how everything else relates to information that is restricted by state or federal law. Because it's been now better part of 3 months since that December 18th order was entered, with only one document being released last week. What is it about everything else that requires it to still remain under seal, otherwise restricted by state or federal law? Until next time, this is Kathy. Thank you for joining us here today.